This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to talk about negotiating settlement of a first-party property claim. After the adjuster has completed the bid comparison and established the objective amount of the loss, he or she should meet with the insured and present each of the estimates and the adjuster's bid comparison to the insured for review and analysis. The adjuster will then advise the insured that the settlement of the building or structure loss will be based on the objective value of the loss determined by the bid comparison. The decision on which contractor to use is always made by the insured, not the insurer. The insured may believe he knows someone who can do the work better, or who from experience the insured knows will satisfy him and will accept the dollar amount offered by the insurer. The adjuster should never demand that a particular contractor be used, since the insurer is only obligated to pay indemnity, not to reconstruct the building. If the insured is satisfied that the estimates cover the entire scope of loss agreed to at the first meeting with the adjuster, the settlement of a structure loss will be amicable. The loss of personal property, whether by fire, water, wind, or theft, is similar to the structure loss in that it requires an objective finding of the actual cash value or replacement cost value of the damaged, destroyed, or stolen items. Therefore, with regard to settling a contents loss, the adjuster must begin with a scope of loss. The claims investigation always begins with the adjuster and the insured reaching agreement on the scope of loss. In a loss to contents, the scope of loss is generated at the first meeting between the adjuster and the insured. The two agree on the categories of property damaged, destroyed, or missing. As with a structure loss, these agreements are not to the amount of loss, but to the general categories of loss that will be used to agree on the total amount of loss. In a typical fire or theft loss, the categories may include 1. A description of each item, for example, a wingback chair or a Bulova wristwatch or a Waterford bowl. 2. The date each item was purchased. 3. The location where each item was purchased. 4. The physical condition of the item before the loss. 5. The replacement value of the item on the date of loss. 6. The place in the structure where the item was prior to the loss. And 7. Whether the item has any antiquarian value or value as an object of art. After the scope has been established, it is then up to the insured working with the adjuster to convert the scope of loss to a dollar amount. Most contents policies issued currently have replacement cost coverage available. That means the insured is entitled to collect, regardless of the condition of the item, the cost to repair or replace with like kind and quality. The only limitation placed on the collection of replacement cost is that the insured must actually replace the item before replacement cost can be collected. Some policies even agree to pay replacement cost value even if the insured does not actually replace the item. These are rare and fairly expensive insurance policies. It is essential, therefore, to read the policy carefully before attempting to resolve an RCV claim for the loss of personal property. The adjuster, faced with an extensive scope of loss created jointly with the insured, is obligated to verify the replacement values presented by the insured. The adjuster must collect documents from the insured like receipts, invoices, and canceled checks. The adjuster must contact the vendors from whom the insured acquired or replaced the particular items to verify that the item was accurately replaced and that the replacement value is accurate. Remember, an adjuster is also an investigator. Claims must be verified, and therefore the adjuster should, 1, visit each vendor to verify the invoice. 2, collect catalogs like JCPenney, Victoria's Secret, Land's End, Duluth Trading Company, J. Crew. 3, collect URLs from providers like Amazon.com, Walmart.com, and the sites for all of the retailers. And 4, maintain a good relationship with personal property replacement services that will use volume buying to replace personal property at wholesale prices. In this age of highly competitive electronics pricing, a computer purchased 2 years ago for $2,500 may be replaced with a new, more powerful computer for $800. On the other hand, a piece of furniture purchased for $500 4 years ago may cost anywhere from $1,100 to $3,500 to replace. Moore's law applies with computers, but not with furniture and other fixtures. The adjuster must keep up his or her knowledge of the value of personal property to assist in reaching a valid and reasonable settlement with the insured. Now, when there is a guaranteed replacement cost coverage provided by some first-party property insurance policies that promise to pay the cost to repair or replace regardless of the policy limits stated in the declarations page of the policy. These guaranteed replacement cost policies are not limitless and are rapidly disappearing from the marketplace. For example, the fact that an insured did not understand notice from the insurer informing her that her guaranteed replacement cost coverage was being eliminated is her fault. The insurer did not represent anything regarding the insurance policy. In Davis versus Allstate Insurance Company, a 2001 decision of a Florida district court, against the demands of the insured, limited coverage to the cost necessary to repair the damaged structure, because the amount owed under the guaranteed replacement cost provision was measured only by the amount necessary to repair the existing damage to the insured property. Allstate, the court found, properly paid the amount of replacement cost coverage, and any additional amount was to be borne solely by the insured. A typical guaranteed replacement cost form provides, quote, pursuant to the endorsement in event of loss, as an alternative to payment of the basic coverage limit, MOE, the insurer, agreed to pay not more than the lesser of 1, the replacement cost of that part of the building damaged for like construction and use on the same premises, or 2, the necessary amount required to repair or replace the damaged building. Close quote. This was Patton versus Mutual of Human Law, a 2014 decision of the Oregon Court of Appeal. In Weidman versus Erie Insurance Group, a 2001 decision of the Indiana Court of Appeal, who was tasked with reassessing an appraisal award that posited that both the actual cash value and the replacement cost of the loss was $113,000 because of a recent remodeling. The insurer withheld the profit and overhead attributed to a general contractor because the insured intended to do the work himself. The policy limited the insurer's payment for replacement cost expenditures that do not exceed the smallest of the replacement cost of that part of the dwelling damaged, or the amount actually and necessarily spent to repair or replace the damaged dwelling. The court found that the clear and unambiguous language of the policy limited the insurer's obligation. It was required to pay no more than the amount actually spent on the repairs, even though nothing in the policy gave the insurer the right to withhold the overhead and profit. Since the insured did not prove he spent more than the insurer paid, the case was remanded for trial on that issue alone. When a policy explains guaranteed replacement cost coverage and provides guaranteed replacement cost coverage to buildings, it states, quote, "We will settle covered losses to buildings under coverage A, dwelling, and coverage B, separate structures, at replacement cost, regardless of the limits of insurance shown on the declarations page, subject to the following provisions. We do not cover any costs required to replace, rebuild, stabilize, or otherwise restore the land. There is no right to obtain payment to stabilize the land, even if the structure cannot be repaired without first stabilizing the land." The cases teach that with replacement cost coverages, an insurer should work with the insured to establish that the insured has actually repaired or replaced the structure. The insurer should withhold payment of more than replacement cost until the money is actually spent. In most policies, that means the insurer pays actual cash value and agrees to pay the difference between actual cash value and replacement cost when the insured proves that he or she has actually spent the amount that was agreed to be the difference between actual cash value and replacement cost. Homeowners' policies, except in a valued property state, agree to first pay actual cash value and the difference. As a result, the limit is not necessarily the amount listed on the policy when there is a guaranteed replacement cost policy, but the amount actually expended by the insured to replace. In Parks versus Safeco, a 2016 decision out of Idaho, the Supreme Court of Idaho was faced with a claim by an insured for the limit of their policy and bad faith because the insurer paid only the amount expended by the insured to replace the dwelling. David and Christina Parks appealed from a district court dismissal on summary judgment. A wildfire destroyed the Parks house, which was insured by Safeco. The Parks purchased an existing house, and Safeco paid the Parks a total of $255,000, the cost of the replacement house less the value of the land. On June 28, 2012, a fire in Pocatello, Idaho, destroyed the Parks house. The Parks house was insured through a homeowner's policy issued by Safeco, which provided a total home coverage of $464,875. Following the fire, Safeco hired an appraiser to determine the actual cash value of the Parks destroyed house. The policy defined ACV as the market value of the property in a used condition equal to that of the lost or damaged property, if reasonably available on the used market. Mrs. Parks understood that pursuant to the policy, Safeco would pay the ACV as soon as the appraisal was completed, but the replacement cost payment would be handled once a replacement was made. The Parks sued Safeco, saying they wanted the full $440,000. The appraisal, however, was completed and stated that the actual cash value of their house was $169,000, and accordingly on July 26, Safeco mailed a check for $169,000 to the Parks. Although the Parks believed the actual cash value of their house was higher than the appraisal, Mr. Parks acknowledged he had no grounds upon which to argue. Safeco clarified to Mr. Parks that the ACV was not the complete payment, it was just the beginning. In a letter sent with the ACV payment, Safeco informed the Parks that the limit of their policy was $464,875 and stated that in order to claim the full replacement cost, you must replace the dwelling. The letter included the relevant portions of the policy and informed the Parks that Safeco was in the process of obtaining a replacement cost bid for equivalent construction of your home. You may replace your dwelling on the existing location, build on a new location, or purchase an existing home. On September 20, Belfour Construction, which was hired by Safeco, estimated it would cost $440,000 to replace the Parks home using equivalent construction. But rather than doing so, the Parks purchased a home in the Idaho Falls area for $300,000. The house was valued at $255,000 and the land was valued at $45,000. Mr. Parks acknowledged that the amount actually incurred as a result of the fire, in terms of replacing the existing structure, was $300,000 less the value of the land. Safeco agreed to pay the additional undisputed amount for the difference between market value and replacement cost of the dwelling. The district court held that the word replace was unambiguous. The district court noted that the Parks had three options to replace their destroyed home. They could rebuild at the same location, build a house in a new location, or purchase an existing home. Despite the fact that the definition of replace varied depending on context, the district court held it was not reasonably subject to conflicting interpretations. There is nothing in the policy that allows plaintiff to purchase a less expensive home and then claim the difference between the less expensive house and the cost to rebuild. This video was adapted from my book, Zelma on Insurance Claims, Part 107, Second Edition, which is part of a 10-volume treatise called Zelma on Insurance Claims, all of which are available as Kindle books or as paperbacks from Amazon.com. If you found this video to be useful or of interest to you, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos, blog postings, so that you know when they happen. Thank you for your attention.